When negotiating a settlement in a medical malpractice case, an accident case, or even a wrongful death case, can the defense put on certain restrictions or conditions with any settlement offer? You want to know the answer? Come join me for a walk around the neighborhood as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is yes, they can. So here's what I mean. Let's say you brought a medical malpractice case against various doctors. And now, during the course of your lawsuit, the defense reaches out to us and says, hey, listen, we'd like to try and start negotiating. And now, over the course of the next few days or few weeks, there are negotiations that are occurring. We rejected a number of different offers that they made. Now, finally, the defense comes back and says, hey, listen, we've consulted with our experts, we've consulted with our principals, and this is our final offer. If you take it, that's great. Case is done and settled, and we're finished. If your client refuses to accept this settlement offer, you have 1 week in which to decide, and if they choose not to accept it, we are withdrawing our offer, and that money will never be offered again. Can they do that? Is that appropriate? Is that ethical? Is that acting in good faith? The answer is yes, 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 and most likely yes. So what do I mean? When the defense makes a settlement offer, there will come a point in time where they turn around and say, listen, this is our best settlement offer. This is our line in the sand. We are not going to offer a dime more. Now, please take that back to your client and discuss it. And if they do go ahead and accept the offer, great, case is done and settled. If they choose not to go ahead and accept the offer, we are not going to make any additional offers. We will have to see you at trial, and we will let a jury decide how much your injuries are worth. Now, if they go ahead and reject the offer, we are also letting you know that as a condition of this offer, if they don't accept it within 1 week, we are going to unilaterally withdraw that offer and it will no longer be available. So if you come to us in a week and a half from now, guess what? That offer will no longer be available. That money will no longer be available. Can they do that? Yes, they can do that. Is that acting in good faith? I would argue, no, that's not good faith. However, there are some instances where the defense may have a bad taste in their mouth from prior dealings with your attorney. There may be bad history between your attorney and the insurance company who represents the various doctors whom you have sued. There may have been a prior experience where a settlement offer was originally accepted and then they went back on their word and now they had to go to trial in order to resolve the case. In that instance, a lack of trust developed. There could be many other reasons why the defense and their insurance company, their principals, have made a decision to include this condition, this restriction, in order to go ahead and try and settle this case. Now, does that put pressure on you and your attorney? The answer is yes, it does. However, it also makes it much easier to make a decision. Why? Because at this point, it's all or nothing. Either you accept the offer or you don't. If you don't accept this offer, you know you're going to trial. And if you have no problem going to trial and rolling the dice, knowing that there are risks of going to trial, so be it. But that's a conversation you have to have with your attorney, and a detailed conversation talking about the risks and benefits of accepting a settlement offer. Yes, there are risks of accepting an offer, as well as the risks and benefits and alternatives of going to trial. So let me tell you what I mean. If you accept a settlement offer halfway through your lawsuit, the risk is regret. You may regret accepting this settlement offer a month from now, 2 months from now, a year down the road, 2 years down the road. Maybe you need additional care and treatment. Maybe you will need additional surgery. Maybe you had not yet considered other possibilities and ongoing medical care that you would need as a result of these injuries caused by these careless doctors. In that instance, you may ultimately turn around and say, you know what, I should have held out for more. My injuries are worth much more because I need all this additional care and treatment. However, that is a risk of accepting an offer early. Another risk of an early settlement offer and a settlement acceptance is that when the defense makes an offer to settle, let's say halfway through your case, they are going to expect and hope that they can achieve a settlement at a significant discount compared to if you went to trial or tried to settle this right before trial. Now, why is that? It's because they know that by settling a case now, it avoids the necessity of having to spend a tremendous amount of money to prosecute your case, to go to trial, and everything involved with going to trial. So there is a great expense involved with proceeding forward with your case, and the defense knows this. And if they go ahead and try and resolve this at an early stage, they are going to try everything possible to try and reduce the amount that they have to pay. So you expect to get 100% value of your injuries in a settlement. The defense may see it differently and say, you know what? We think to settle this case right now, we will give you 70% of the value of your injuries, or some other number, some other percentage. Now, there is also a risk of going to trial. And that is, even though you believe you have a great case, even though you have great experts, even though your attorney tells you it's a solid case, you can still lose your case by going to trial. Maybe the jury doesn't agree with you and your experts. Maybe the jury doesn't believe the doctors did anything wrong. Maybe the jury comes to the conclusion that the doctors did do something wrong, but whatever they did not cause or contribute to your injuries. On the other hand, the jury may come back and say, you know what? We believe that the doctors were careless. And yes, we believe that that carelessness caused you harm and injury. However, we don't believe that your injuries are as significant as you claim them to be. In that instance, now the jury comes back with a verdict in your favor. However, it is substantially less money than what you were originally offered by the defense during your settlement negotiations. And the risk is you don't know what a jury is going to do. So there are always people who turn around and say, I don't care what the risks are, I'm going forward to trial. You and your attorney have to have that conversation about the risks and benefits. So getting back to the question that I raised in the title of this video, can the defense turn around and put restrictions on their settlement offer? And the answer is yes, they can. Is it good faith? No, I don't believe that's acting in good faith, because once you make a settlement offer, that money should be there and remain there. There should be no reason to take that money off the table. So why do I share this quick information with you? I share it with you just to open your eyes and to help you understand how these types of cases work in the state of New York. I realize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you are thinking about bringing a lawsuit, but have not done so yet, and you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.